and tenant exclusive negotiation period. This is the requirement that property owners of residential rental property with 3 units or fewer offer tenants the opportunity to purchase a property prior to listing it for sale or prior to accepting a third-party offer. This gives tenants what's called an exclusive negotiation period of 30 days. Which is the 30 days they have to make a decision about whether they wish to make an offer on the home. The same basic process is followed whether the owner has decided to sell and wishes to list the property, or whether they have received a third-party offer they wish to accept. I will be able to send and share a detailed pictorial instruction sheet for operating the portal. Probably some of you have encountered the right of first refusal portal, and you may have encountered some barriers or frustrations with it. And so I want to make sure that I'm available to help with all of that as needed. But when you go into the portal, you will note that there are 2 different forms. One form is called an exclusive negotiation period form. The other is called the right of first refusal form. They are basically the same form. The only difference between them is what they call the offer. And if in one of your deals or transactions you inadvertently use the wrong form, we will not come after you looking to fine you or do anything bad to you. We will maybe ask you to go back and do the other form, or even cross out what it calls the offer and call it something else, but it's not a big deal. They are essentially the same form. They contain the same information. It's just that the exclusive negotiation period form is the one that you use when you have an owner proposed offer, where the owner is proposing a price to the tenant and soliciting an offer from the tenant in the absence of a third-party offer. And the right of first refusal form is the one that you fill out in the scenario where you have a third-party offer on a property that you wish to accept, and you are asking the tenant to match the third-party offer. And these regulations again went into effect October 1st of 2024, and that is when the portal first opened to landlords for submissions of and for entering the information that then allows you to download the form that you would then mail to your tenant to initiate the process. So we covered a little bit. The right of first refusal is the scenario where you have a third party offer. And in either case, whether it's exclusive negotiation period or right of first refusal, you would provide the tenant with a written notice. It's a specific set of forms that you create in the online portal and then download that gives the tenant the information that you intend to sell the property, and you offer the proposed price or the third-party offer price to the tenant. And when you put this information into the portal, it is automatically recorded with the state. You do not have to mail or email us anything. When you put it in the portal, I can pull it up and I can see it when I'm sitting at my desk. Once you when you have sent the form to the tenant and you send it first class mail, we do encourage people to send it first class mail. That is the legally required method. That starts the clock on their 30 days. The reason I say send it first class mail, a lot of people are sending it certified mail. That isn't necessarily the best idea, because sometimes tenants get confused and they think that if they do not sign for the certified mail, that they can extend the window of time that they have to make a decision to purchase the property, or they can somehow delay the sale. This is incorrect. If they call me and ask me about it, I will tell them that that is incorrect. But it is best if you send it first class mail, and it is also a best practice to send it by other means. You're not required to send it by other means, but you absolutely can send it by other means that you might use to communicate with the tenants, because the more certain you make that they receive it, and that they receive it as close to the start of the 30-day period as possible, the more time they have to figure out and make a timely decision as to whether or not they want to make an offer on the property, the more time they have to potentially get financing together to be able to make a viable offer, to understand the process if they've never perhaps even thought about buying a home before. So it is required to send it by first class mail, but you absolutely can also send it by email, also deliver it to the unit, also put it in their hand, also text them and let them know that it's coming. Any way that you communicate with your tenant, you can duplicate the sending of the forms, and that is usually ultimately in the best interest of the timely process of the exclusive negotiation period. So with regard to the right of first refusal and the exclusive negotiation period, who counts as a tenant for purposes of these laws is somewhat different and more restricted than who counts as a tenant for Maryland landlord tenant law overall. So in order to have a right of first refusal on a property, your tenant must be named on a written lease. This can be somebody who is named as an occupant, but their name must be one of the parties who is living there in an authorized leased official capacity. And they must have occupied the rental for at least 6 months. This is because the law is intended to preserve the stability of communities and give longtime tenants, residential tenants who are potentially financially capable and qualified and credit worthy to purchase the home, the opportunity to do so. It is not intended to apply to people in Airbnbs, short-term rentals, corporate rentals, those types of circumstances. Now, in the absence of a written lease, but where the tenant has lived there for 6 months or longer, if there is no written lease, Maryland law considers that to be a legally binding oral lease with a default term of 1 year. So if your tenant does not have a lease at all in writing, they have a 1-year lease and they are entitled to the right of first refusal. But if there is a written lease and the tenant says, well, I'm on the lease, but when you send the right of first refusal form, they say, well, actually, Joe, my cousin over here, he's been living with me for the last 8 months. And I just didn't mention it, but he's a tenant here too. For eviction purposes, they would be correct. Joe's the tenant as well, even if he's not on a lease, Joe's been getting his cell phone bill there. He's a tenant for eviction purposes. For right of first refusal purposes, Joe is not a tenant because Joe is not the party who you lease the property to, whose name is on the lease.
And that's even if he had been there for 6 months.
Even if he had been there for 6 months, if there is a written lease in place, but Joe is not on it, then Joe does not get the right of first refusal.
I'm a little bit confused if this is an or an and
Right.
for all of these, right? So if the tenants are named on the lease, or the tenants have occupied for at least 6 months, comma, but there isn't a written lease. It's pretty technical as far as what qualifies and what doesn't, it sounds like.
So these are all ands. Tenants must be named on the lease and.
But you said there was an oral lease that could pop up even if they're not on a lease.
Well, that is in the absence of a lease, and I should probably add this to the slide. That's in the complete absence of a lease. So, the oral lease, is only, I've been letting my family member live in this property without a lease for the last 10 years, and they've been paying me $1,200 in rent every month. But no, we never put a lease together because they're my cousin. Your cousin has a lease. And that's based on the law in Maryland as to when a tenant is considered to have a binding oral lease.
Thank you.
Tenants, so it's also only applicable to active tenants. That is tenants who are currently living in the property and have not either been legally evicted or moved out voluntarily. Once a tenant vacates the property or is legally evicted, they no longer have a right of first refusal. It does not apply to former tenants. And it is also within a property owner's right to wait until the conclusion of a tenancy to make a decision as to whether they want to sell a property, what they might want to price the property for. If somebody wants to wait until a tenancy has concluded to list the property, then they do not have to offer the right of first refusal to the tenant, because maybe sometimes that comes up. Sometimes people want to wait and renovate the vacant property because they believe that they might be able to get a better price for it, or they might want to wait to a different market season and make a decision or have it assessed as to how they want to price it. And maybe they don't know whether they want to sell the property or when they want to sell the property or how much they want to ask to it for the property, and they want more time to make those decisions. They are allowed to wait until the end of the tenancy. If you want to sell a property with a tenant living in it, even if the tenant is late on rent, even if the tenant is holding over, even if the tenant is under eviction proceedings, if you want to list the property or accept a third-party offer with the tenant living in the property, you have to offer the tenant the right of first refusal or exclusive negotiation period full. There are also certain types of sales that are exempt from the exclusive negotiation period and right of first refusal requirements. Those types of sales are sales to a business wholly owned by the owner, sales or gifts to a family member of the owner, sales under eminent domain, sales that are court ordered or a bank sale or a tax sale, sales to a nonprofit or government entity, sales by an estate fiduciary as part of the disposition of an estate, and sales of a single multifamily property with 4 or more residential units. I usually stop here and make sure that I clarify that condos are considered one residential unit. So if you own 10 individual condos in a condo building, each of those condos is one residential unit. I also often get the question, well, what about mixed use properties? Because sometimes we have situations where you have a building with, for example, 2 shops and 2 apartments. In Baltimore and Annapolis, you have storefront with apartments over them, right? And in those cases, the law does not specifically provide guidance on what to do with mixed use property where the number of residential rental property would potentially have the right of first refusal apply to selling it. In those cases, we are giving the implementation guidance, again, not legal advice, that it is a best practice to offer all the residential tenants the opportunity to buy the whole package. So what people are doing in those instances where they are trying to sell a property with 2 commercial units and 2 residential units, that it is not practical or reasonable to expect that the seller would separate out the residential units and sell them separately to their separate tenants. In those cases, they are offering the residential tenants and the residential tenants only, because it's for residential tenants, not commercial tenants, the right of first refusal to buy both units of residential and both units of commercial altogether. And they may not be able to afford that, and that's okay, but they can't come back and say, you didn't give us the opportunity. You violated our right of first refusal as residential tenants. So what often happens is they've had the opportunity. Now maybe they can buy it and that's great and their money is green. Maybe they can't and they can't afford it, so they decline, and then you can move on and proceed with the sale. That is the way that people are handling mixed use properties when this question has come up. So we already covered the difference between exclusive negotiation period and right of first refusal. When you are doing an owner proposed offer and you are coming up with a price to offer to the tenant, It's important to note that you are expected to offer a market reasonable price. You are not expected to offer the tenant a below market price. The standard is market reasonable, and you should start, you get to set the price. The seller gets to name their price, based on what they think that is market reasonable for the property, or what they want to offer the tenant. And we do have cases of owners voluntarily offering the tenant a below market price, because they like their tenant and they want to be nice to them, but that's not the expectation that people will do that. So you should start with a price that you are comfortable and happy to receive for the property, because if the tenant says, yes, thank you very much, I will buy the property for this price, sounds good to me. And then the next day you get an offer from a third party for $30,000 more than the tenant's offer, the number that you offer to the tenant is binding. You have to accept that price from the tenant. If the tenant says, yes, sounds like a good deal, let's go forward. The other terms are negotiable, with the exception that the seller cannot restrict tenants' financing options and cannot require the tenant to waive inspections. So you cannot require the tenant to match a cash as is offer, because if tenants could be required to match cash as is offers, the law would pretty much be moot. It's intended to give qualified tenants who can afford to buy the home and are creditworthy the opportunity to compete with comparable buyers using financing to purchase a home as a primary residence. And this is intended to give tenants an opportunity to compete for the homes that they live in and the communities that they're stable, invested members of, with investors and flippers. And so that's why those protections are there. The other terms, besides what I have just gone over, all of those other terms are negotiable, and the market reasonable standard applies. So if a tenant says, yes, I very much would like to buy the home, sounds like a good deal, I'll need 6 months to get my financing together, so we can't close for 6 months. That can be enough. You can apply a market reasonable standard to the other terms, and that's what the negotiation period is for. Negotiate with them and go back and forth and see if you can come to a deal. Also with regard to not being able to require tenants to waive inspection, you can't require them to waive inspection. They can elect to waive inspection if they want to. And you can also stipulate that you decline to make repairs. You can say that it's as is, you just can't require them to waive the inspection. There is a protection, basically a market-based protection that we refer to as the 10% rule. This states that if no agreement is reached during the exclusive negotiation period, the owner can list the home for sale. However, if the owner receives an offer that is more than 10% below any offer they negotiated on with the tenant, and they intend to accept that offer, then they must offer a new right of first refusal notice to the tenant for the lower offer. So you cannot come to the tenant and say, I would like to receive $300,000 for this property. And let's say the tenant counter offers at $290,000. And you say, no, $300,000, my price is firm. $290,000 is not enough money. Sorry, Charlie. Okay, that's very well and good. You can do that. You can say my price is firm and you can decline a counter offer. However, if you do that, and then your neighbor who you like very much offers you $270,000 to buy the property while the tenant is still living there, and you say, well, I would rather, I like this neighbor so much, I will sell them the property for $270,000 where I wouldn't sell it to my tenant for $290,000. You've got to go back and reoffer it to the tenant, and there's going to be another 30-day window. This only applies to the initial offer, the acceptance of the initial offer. If something were to happen, such as you accept a offer that is comparable to the initial offer that you made to the tenant from a third party, you accept $295,000 from that third party, but as the property is under contract, the pipes freeze and they burst and they flood everything, and you say, oh, well, I guess I better go back and lower the price because the condition of the property has changed. That would not be subject to a 10% rule because it's not concerned with the initial offer. These regulations are just concerned with the initial offer. So you would still be allowed to proceed with the contract in that type of circumstance. It's usually a question people ask. And again, in the case of a third-party offer, it is also the case that if you offer the tenant the opportunity to match a third-party offer that you've received and you intend to accept, if you 2 days later, you get an offer $20,000 higher from a different third party, you can go back and say, no, that one, I'd rather you match that one. Once you make the offer to the tenant, you're bound to that offer. And going through the timeline period, so sometimes people ask me, well, why 30 days? Because 30 days seems like a long time. 30 days is a reasonable time for somebody who might not have ever contemplated or assessed whether they're able to buy a house or whether they want to make that leap. And so that is the window that gives the tenant enough time to make what can be a significant life decision. And sometimes they need to gather some more information or get some counsel and some guidance on whether that's feasible for them to have a reasonable shot at being able to put together an offer and successfully purchase. If the tenant does not respond, you can list the property on the 31st day. If the tenant declines in writing, and once they decline and they say that and they put it in writing, you can proceed to list. You don't have to wait the rest of the 30 days after the tenant has given you a written decline. You've offered them the option, they have formally declined it and documented it. There is a provision that, so once the tenant makes an offer or a counter offer, you have 5 days to respond. So let's say if the tenant were to give you an offer and sign the form and hand it back saying, yes, I would like to meet your terms. I would like to buy the house on day 29. You have 5 days to respond to them and move the negotiations along. To go over the next steps, figure out what comes next. You don't have to take all 5 days. You can respond back to them that afternoon. That shortens the window that you're waiting between when you can potentially market the property to a third party if the tenant's offer doesn't work out. The tenant then has 5 days to answer, which is the industry is interpreting this as the tenant's 5 days to answer the owner's response to their offer as the time that they have to bring an offer package forward that is viable, to have their financing approval, financing pre-approval. But at the point where the tenant makes an offer on the 29th day, it is advisable and in your best interest to communicate expectations about the next steps and how they proceed in order to be able to realize the goal of buying the home. And a lot of people also ask, well, what if the tenant is unrepresented by a real estate agent? So a lot of times the tenants are referred to in the paperwork, for example, the Maryland Mortgage Program, and referred to housing counseling agencies. Sometimes housing counseling agencies act on their behalf. And when tenants call me, and this happens a few times, they'll call me and they'll say, well, I don't know, is this a market reasonable price for this home? What should I do? And I say, I am not a real estate agent. You should talk to a real estate agent. If you're prepared to buy a home and you need help handling real estate negotiations, you should call a real estate agent and pay them to help you with that. That is what I tell tenants. And so I would encourage tenants when they're in the negotiation process to get representation.
Hey, just really quick, based on what you said, can the tenant's response be does it have to be by email or can it be text if they come?
as long as you can put a record of it and having occurred in front of a judge, then, that would be more of basically if. I think the safest is to make sure that you have something that you would wanna take to court. If they were to come back and say, oh, no, I didn't decline, my cousin signed it for me, or something like that. Make sure it's a document that would hold up if they change their mind down the road to be on the safe side. Again, not legal advice, just best practice. And when in doubt about those kind of particularities of process, definitely ask an attorney or legal professional as well to be sure, when it comes to policy and process on things that aren't specifically spelled out in the law. And then, oh, the other thing I should mention, so if a deal cannot be reached between the owner and the tenant, as they are negotiating and the negotiation period concludes. But maybe they're still negotiating, maybe they're still going back and forth, this has happened a few times. The tenant can continue to negotiate, they can continue to negotiate, but now the tenant is just competing in the market against other, potential buyers that have an interest in the home. So you don't have to stop negotiating with the tenant just because their negotiation period has ended. You can continue to negotiate, but they no longer have a protected window. And the protected price expires with the negotiation period. Except at the 10% rule continues to apply. Then another thing that people ask about is how this process intersects with existing landlord tenant laws and required notice periods. So for example, there's a required notice period if you want to terminate somebody's lease. So a lot of times people ask me, can I send the exclusive negotiation period notice to the tenant at the same time as I send them a 60-day notice that I'm not renewing their lease? Yes, you absolutely can. They can run concurrently, so you can wrap up your 30-day negotiation period with the tenant before their lease ends, and it can run concurrently with their other notice periods. Also, all terms and obligations of the landlord-tenant relationship persist until the ink is dry and the tenant owns the home, if they are trying to buy the home. So any responsibilities that you have as a landlord while you're in contract negotiations with the tenant, you continue to have landlord responsibilities. If their toilet falls through the floor 10 days away from close, you still have to fix it. And it doesn't change anything about the existing legal relationship and obligations between the landlord and tenant. It's a separate process. And so, of course, you have to honor all terms of the existing lease. If the tenant does not want to purchase and they still have 6 months left on their lease, and you want to sell to a third party, you're selling that property with the tenant in place, and the third party is becoming their new landlord and would take over all of the responsibilities of being their landlord when that party becomes the new owner of the property. And then, of course, you have to provide reasonable notice and consideration to tenants if you're accessing the property to make repairs or to show to prospective buyers. As of October 1st, the definition for what is considered reasonable notice is being made more specific. Reasonable notice is considered by the state of Maryland to be notice, 24-hour written notice, that you will be accessing the property during a window of time, and the window of time should be between the hours of 7 a.m. and 7 p.m. Monday through Saturday, or at a different time by mutual agreement. So you can't come on Sunday or at 8 o'clock unless the tenant asks you to, or asks for an alternative time and suggests a time outside of those hours.
Real quick, before we get away from that,
Yeah.
so the only time I've encountered this there's often a lot of times where you basically need to interrupt the tenant's life at that point, whether it's showings. Then after there's accepted, there may be contractors, there may be inspectors coming in. And the one time, the tenant was not very happy that all these people were coming in, so it was a lot of work trying to figure out. What's actually required, and then there's sort of best practice to be courteous, and then what's really legally required. But generally for all of those things, even if it's not an emergency, 24 hours notice, Monday through Friday, Monday through Saturday, 7 to 7. The tenant is supposed to let that inspector in, for instance, at that point.
They are supposed to. I think that it is advisable, where they are workable with, to work with them, to, you know, follow the golden rule and treat people as you
Of
would
course,
wanna be
yeah.
treated if you were a tenant, be reasonable, you know, nothing about any of these laws prevents tenants from being jerks or prevents landlords from being jerks, you know, that, still happens, and yes, sometimes tenants can be unreasonably difficult about access to units, and that's something that I clarify. Also, sometimes landlords have unreasonable expectations and can be pressing to be pretty disruptive to a tenant's life. And I go over a lot of this when I do the tenant bill of rights training. Also, we have some more in-depth discussion of how to handle these matters fairly and what expectations should be. But you know, summarizing, treat somebody as you would want to be treated, and you know, if they're being unreasonable, they're being unreasonable. There's not too much we can do about that other than, you know, sometimes people do wait until the conclusion of a tenancy to market a property for exactly that reason, because you can't, you can make them let you in, but you can't make them clean, so.
Right, I mean, could you, because there are teeth hypothetically, if the landlord is unreasonable, there are ways that the tenant can go after the landlord. If the tenant refuses to let somebody in after 72 hours notice and checking, can the landlord just use their key and enter at that point, or is that a trespass?
So if you have provided 24 hours written notice that you are coming at a window, okay? And the tenant has a right to be, the reason they have a right to be informed is they have a right to be present in the property. So they can say, if you say I'm coming between 12 and 5 on Monday to do X, Y, Z at the property, the tenant has a right to be bodily in the unit the whole time you're doing whatever it is. Do not ask the tenant to leave the unit. Whatever you're doing in there, the tenant has a right to be present in the unit because it is their home. Except, I mean, I guess there might be situations where it's dangerous to their safety, like if you're fumigating a unit or something like that, that would be an exception. But in general, you can't ask them to leave the unit. So that you can enter into the unit, you do have the right to enter in the unit for at the stated window of time with the proper notice using your keys. That is, and if they call my office and ask me about it, I say, nope, your landlord has the right to go in and fix your stove or go in and change your air conditioner filter, as long as they gave you the notice when they would be there, so that you could arrange to be there if you wanted to. Because usually tenants' concern is they don't want somebody in their home without them. They don't want,
Sure.
so that's why it's to allow them to arrange to be present.
Yeah, I mean, it's kind of the nuclear option. You never want to enter the home against the tenant's will. I'm just trying to think about the worst case scenario so that we can be prepared and give good advice if that does arise.
Yeah, and also, you know, from a safety perspective, it may be legal, but legal isn't necessarily advisable.
Yep.
So. So we've talked about 60 days notice and making required repairs. Okay, I think we covered all of these things. Oh, the other things that are specific to the Maryland law for people who have also worked with TOPA in DC, there are some key differences with the Maryland right of first refusal. One of them is that the tenants cannot assign or transfer their right of first refusal to a third party. They cannot sell, assign, or transfer their right of first refusal to somebody who is not a tenant of that unit. They also cannot waive their right of first first refusal. So they can only decline to purchase once the right of first refusal is offered. You cannot put something in a lease where the tenant says, I agree to waive the right of first refusal. It's not a right that they can agree to waive. Once the tenant declines in writing, again, you can list as soon as you have the written, decline. The tenants can purchase the property jointly with a friend or a family member of their choice, so long as they are a party to the transaction. They're on the deed, they're one of the buyers of the house. Or they could use a friend or a family member for financing. Sometimes this happens, a friend or a family member who wants to secure somebody's spot to live and thinks it's a good price might actually buy the tenant the home. And that, I believe I've heard of cases already of that happening, and that's a nice thing for them, but they have to, the tenant has to be on the deed and the resident, because the purpose is to allow the tenant to remain in their home if they can find the financing to do that. Tenants can also buy the property jointly. Sometimes you might have a group house where one tenant wants to buy it and become the new landlord for the other tenants. That's okay. They also, if you have 4 tenants in a group house and they all want to make an offer, the tenants can have a bidding war amongst themselves. You can choose the most favorable offer from amongst 4 tenants that are all sharing a property as roommates. And the tenant right of first refusal is based on the designation of the property as a residential rental property and that it's a residential lease. So if we had this come up in a circumstance where they were renting a home, but they were using it for church services, and the landlord who rented the home called and said, well, these tenants aren't living there, they're holding church services there, do I have to offer them the right of first refusal? And we said, yep, because they were on a residential lease and they rented a residential home and they happened to be holding church services there. So if your tenant rented your condo in order to have a quiet place to telework, but they don't sleep there at night, that doesn't matter for purposes of this law. They're still considered a residential tenant on a residential lease. And then this is my contact information, so you can follow up with me if you have further questions. I will also provide for the organizers of this later today, the guide, the pictorial guide for the portal and some other resources that they can share, as well as the slide presentation. And with that, I'll open up for any questions.
All right, there's a lot of questions, amazing questions in this chat box here. So I'm gonna go ahead and start at the top here. So for those, yes, the recording will be sent out. Are we able to get the slides?
Yes.
Okay, so we're gonna send an email. It won't be till tomorrow, but the email will have all the recordings, the recording, the slides. We actually have additional information that our broker here as well has as well. So we'll put all that in an email, as well as Emily's amazing information, so we can reach out. So some of the questions in here, what happens when the tenant refuses to respond to the notice? Now, I think these might have been answered already. We're just gonna kind of go back in time just to make sure they're answered. So
when the tenant refuses to respond to the notice, this is why I said send it to them by multiple means, okay? Because you want to make sure you save the documentation that shows that you sent them the notice, okay? So they had the opportunity to receive the notice, just as an extra layer of diligence. But if they don't receive or respond to the notice, then they miss their window. The 31st day, you can go ahead and list the property. It's an expectation that people will receive important legal correspondence at their home address, that they will check their mails or check their emails, because there may be information that they might need that might be relevant to their best interest, that is going to come to them through reasonable means of communication. And if they don't respond, and you have every reason to believe and know that you did everything you were supposed to do to get it to them, then you don't have to worry about it. Do your very best to make sure that the tenant does receive the notice, you know, that because sometimes people are like, well, maybe I'll just send it and hope they don't see it or hope they don't check the mail. That's not really a good idea. You wanna make a good faith effort to make sure that you communicate that the notice is coming and they should look out for it.
So for the notice, does each occupant need separate notice?
Yes, I would say err on the side of giving each occupant a separate notice that is of legal age. I mean, if it's a family of four and they're, two parents and a 5-year-old and a 3-year-old, the 5-year-old and 3-year-old do not need their own notice, but the parents do.
Next question, is a foreclosure sale excluded from first right of refusal?
Yes, foreclosures are one of the exceptions.
All right, okay, so I'll read this one, it's a little longer here. So it states that if you are renting to a family member and they have a verbal lease, you have to do the first right of refusal. But then it says you don't have to do the first right of refusal if you're selling to a family member, can you expand on?
Okay, so, it's whether so if you are selling the property, let's say, so you have, we'll call it cousin A, who is your tenant. And cousin B is the family member who you are selling the property to. So the question is, if I am, or maybe you're selling the property to your son or your daughter, okay? So you do not, if the tenant is your family member, and the person who is buying the property from you is also your family member, then you do not have to offer the right of first refusal to your tenant because you're selling the property to your family member. So it would be an exempt sale because it's a sale to the family member. And so it doesn't matter if the tenant is related to you. In general, it doesn't matter if a tenant is related to you for purposes of landlord tenant law at all. If they don't have any extra obligation to leave because they're your family, you should still follow. If you're renting to family, you should still follow all regular procedures that you would with a tenant who is not related to you.
All right, there's one, so scenario. Seller has a tenant now, seller advised property manager of price and asked tenant if interested in buying. The tenant declined, tenant's gonna be out by November 30th. If seller waits to list one day after, no right of first refusal or exclusive negotiation is required.
After the tenant has moved out, the tenant has handed the keys back and voluntarily moved out, then the property owner can list. If the tenant holds over, then they would need to either proceed with legal eviction proceedings on the grounds of holding over and have them legally evicted, or they would need to offer them the right of first refusal while they're still bodily in the property.
Okay, I wanted to jump in. Someone had a question about the forms generally. So one of my questions, as I've been trying to field questions about this, it's like, I think you have to go into the portal and have a property. Are the forms kind of generally available so we can review and show our landlords in advance?
So, yeah, so this is what I've been doing. A lot of people have complained that we stopped making the forms available for download in PDF form online, and we did that because people were using only that means because it is easier than doing the portal, and then they were snail mailing them to my office, and we have a 3-person staff, and I would like to be out here doing training with all of you nice folks rather than doing the data entry for every one of these transactions in the state. So I will email you the form as part of the resource material, because people do find it useful to be able to put all the information together in one place and have a draft of what would go to the tenant, so long as you pinky swear that you'll enter it into the portal and not just mail or email me the PDF. Just use it if you're representing a client who's not computer savvy or who's going to have difficulty with the portal, to decide on the offer information, to review it, to see what the portal will download. And also, it's very, very key when you're using the portal, there's you have to turn your pop-up blocker off. in order to download the form. That is the number one problem that comes up with the portal is people say, I put in all the information, I tried to download the form and it is not downloading. I guarantee you, if you think you turned your pop-up blocker off, you didn't turn your pop-up blocker off. Google the browser you're using, how do I turn my pop-up blocker off in Edge? For an extra measure, add the portal website into the list of sites allowed to send pop-ups in your security settings. It should download. Just really double check that you are turning off your pop-up blocker, that almost 100% has resolved that issue.
Okay, great. And I had a couple other questions.
Sure.
One that was related to the portal as well. And you said you can share with us, there's sort of a step-by-step how to use the portal, because that's gonna be really, really
Yes,
helpful.
I will send that to you.
Okay, awesome, because when I was looking at the statute, the portal was available. In addition to saying you need to send it in a certain manner, there's also reporting requirements to go back to the state. So can you tell us a little bit about? Are there multiple steps to the process where we need to update and say, okay, here it was declined, okay, here's the new terms? Maybe you could spend just a couple minutes kind of walking through that.
Sure, so the main requirement is that you enter into the portal the information that you have made the offer to the tenant. That is the most important part and the piece that we care the most about. It is you can also enter in, once you know the tenant's response, you enter onto your tenant page in the portal. There's a little drop down menu next to the tenant's name, and it has somewhat counterintuitively option to select create offer. You use that create offer and you click on it and it will give you tenant declined, tenant didn't respond, tenant made an offer. And then it also does have options to update the offer negotiations as the offer negotiations proceed. That is less important. It is good to use because it does create an electronic record that you have complete control over, that records all the details of you having followed the process and make sure that your compliance is recorded, and that is totally in your hands and electronically saved in perpetuity, which is the very best way to make sure your compliance is recorded. But the most important part is that you document through the portal that you have sent the notice to the tenant and the information on the offer. It also locks, once you have entered the information in and you have clicked submit, those forms will lock. And the reason they lock is so that you can't come back and put in a higher offer price and say, oh, actually, we offered it at this price. You know, you have to contact us to unlock it. If you hit submit after you have made a clerical error on something you entered into those forms. Also, please email otla.dhcd@maryland.gov. I think the website that the email that it tells you to go to is not as reliable. I will go in there and unlock it for you as fast as possible, because I know that people's deals are riding on this process, and I do try to be responsive accordingly and set up out of office systems if I'm not in to make sure that somebody else is taking over and is moving these things when they occur.
Looks like there's one additional question in here. Do you have to provide first right of refusal to voucher holders?
Yes.
Yep.
Yeah.
I'm sorry, I have one more question that is important. I was very confused by the language in the statute as far as what you're allowed to do maybe during the negotiation process. So would it be illegal for a realtor to informally market the property just to kind of gauge interest, or is it actually illegal to list the property but not go under contract even before the 30 days is up?
So what a lot of people are doing is they are listing properties within brokerage on coming soon status, because my understanding from talking with people in the industry is that there are sometimes the requirement that when you contract to represent a client, you are supposed to do something that could be counted as listing the property within a certain window of time. That's what I've been told. And so
That's partly
with,
true.
yes, like, as I tell tenants who ask me about their negotiations, I am not a real estate agent, but
Call me when people.
yeah. But the people are listing on private status or coming soon status. Also, we are not the thought or the conversation police. If you have a conversation with somebody about the fact that, you want to sell this home, or you are interested in selling this home, nobody's going to come after you. Nobody's listening in on your conversations and is going to come and fine you for having a conversation about selling a home. It's the legal standard is formally listing and formally marketing. So having an open house,
So it does say you can't market it. I was confused by the language, and maybe we can take this offline to figure out. Because really the key is not to go under contract and accept a contract before you give somebody else the opportunity, I guess.
I would strongly recommend against having an open house because it's during the tenant's exclusive negotiation period. We can go back and forth about the letter of the law, but it's gonna create a perception on the part of the tenant that, you're not honoring the exclusive negotiation period.
Sure.
And then there's different exposures or liabilities in this process. There's the state enforcement, which is a $1,000 fine, which is in the scope of many real estate transactions, not very much of a deterrent. But what is happening is title companies are being very zealous, from what I'm hearing, and not processing people's deals if they don't present this paperwork and show that they've, followed this process. And there's no protection against tenants suing if they feel like their rights were violated. So I generally tell people to err on the side of caution if in doubt.
So another question in here. So the landlord has already rented the basement to someone else for the past 3 years. Now renting the upstairs to another family. She's planning to sell the property in the next year or two to the tenants renting the upstairs. Do the tenants in the basement have any right of first refusal to purchase the house? Who's actually?
They probably would. So in general, from a fair housing perspective, if you're selling a house, you're selling a house. And so I would say both tenants would, in that circumstance, have the right of first refusal. And in general, when we're selling housing, we're not supposed to be basing our selling of housing on who we like more, or who we would prefer. So I would say that if they want to sell the family upstairs the house, then maybe they do a rent to own contract or something with the family upstairs, figure out some way of protecting that, basically. But yeah, probably in that scenario where they're just equal tenants, they would both have the right of first refusal before one of them could buy it.
Yeah.
And do agents have access to the portal to enter the data, or is it strictly the owners?
Oh, yeah, I'm glad you asked that question. Agents can absolutely do the portal process on behalf of the owner, so long as they have the owner's permission to do so. They do it all the time.
Please don't do that. I don't like that at all.
That is broker Joe talking.
Yeah, if you are my agent, please do not do that. You can give your.
The broker has spoken.
It's the owner's responsibility to comply with this law.
Yes.
Right?
Yes,
So
that is
I want to
true.
make sure that we can help people and provide all the resources. But once you start clicking those buttons, if you screw something up, now you're on the hook. So just be very careful. Be very careful.
All right, well, Emily, thank you so much. We appreciate you coming in and providing. Again, this is part of our normal Thursday series, and we're able to have such wonderful guests and bring great content because we have tremendous partners who love to make sure that we can do anything necessary to bring content. So I would like to take a few moments just to shout out our sponsor for the day who came in and wanted just to provide us the nourishment. So there's food in our kitchen for everybody who's in office. Pam, you want to come up just so we can introduce you, give you a few quick shouts?
Yes. Got a lot of technology here. Over this.
Is this the camera?
Right where her chair is, where you need to
Oh,
be.
okay, so.
All right, so for everybody, this is Pam Foreman of DML. Pam was gracious enough to provide lunch and also sponsor to make sure that we can bring you this great content. She has a few things that she wanted to go through, so I'm going to throw on her slides and let us know.
Awesome. Thank you guys for having me. One thing that I'm super excited about is a brand new program that we're coming out with. I think it hits the market Monday. So what this is called the Hoper Home Buyer Incentive Program. It's an FHA program that will give the buyer 3.5% of their purchase price up to $13,000 that is forgivable. It doesn't have it follows standard FHA guidelines, so it doesn't have a credit score, income limit, or debt ratio like you would normally see with a lot of the down payment assistance programs. And the way that it works is that they basically need to, it participates with them putting on solar panels onto their home. So I'll have more details on Monday, but it sounds like it's an absolutely incredible program that should be able to help a wide variety of buyers who are cash strapped for down payment funds. So that's the first thing. On my next slides, I'll kind of just dive into these real quick. I don't want to take up too much of your time, and I also don't want you to get hangry on me. Did I lose it? Okay, here we go. So one thing that we've always kind of focused on that I'll just breeze through is that we do a lot of different renovation loans. So we do an FHA, conventional, VA, USDA, and now we actually have a lot of products for investors. So we have an investor fix and flip program. We also have a program that if they want to hold the property, it's about 2%, 2 to 3% lower than what hard money interest rates would be. So if you have any buyers that are open to renovating, whether they're investor, second home, or primary, we have a ton of options, and my team has always focused on these. So we're seeing this come into the marketplace more, and keep these in mind for properties that don't necessarily need to be renovated. So let's say it's a bank-owned property where the septic is failing, or let's say that it's a property where you may just want to put on an addition. We had a beautiful property last year in Ellicott City where the buyer turned the sunroom into a main level master for their in-laws. So you can really get creative with these. So if you have a scenario, I'd love to chat with you about that. So this slide kind of talks about the fix and flip program. It goes up to 85% LTV down to a 660 credit score. So this is for your investors that are looking to renovate and sell.
And have properly notified their tenants.
That's right. Yes, exactly. We also are seeing a lot of non-QM loans. These are what are considered non-qualified mortgages. So if you have a buyer who doesn't qualify off of standard income documents like W-2s, tax returns, pay stubs, we can also qualify them off of bank statements, 1099s, or also if they're an investor, we can use their lease or what the property would rent for to qualify them for the mortgage. And then lastly, we're also still doing tax ID loans. These are for a lot of times for foreign nationals who may have been in the United States for several years. They build credit and pay taxes using their tax ID number. A lot of the Spanish-speaking population qualifies for these type of programs. And we do have a Spanish-speaking loan partner if you come across a transaction for someone that speaks Spanish. The one thing I'll also touch on is that a lot of these programs are great for marketing. So if you're looking to fill up your social media content, I can create flyers for any of these programs. They're really plug and play. It's a nice way to have something at your fingertips that you don't have to think through, that just keeps you top of mind. And you never know where you may dig up a buyer that falls into these programs. Also, I would recommend putting them on your Google business page. For example, if someone Googles ITIN mortgage, and you have posted about them, you may be the one that they actually reach out to you for that type of program. Down payment assistance, I already kind of touched on a little bit. We do, of course, offer the Maryland Mortgage Program. We have the Essex program, which also does not have an income limit or does not have any restrictions. So if you have a buyer, let's say, that owns other real estate, we do have financing for DPA funds for them. That program also allows co-signers. So if you're running into hiccups with the standard DPA or grant programs, we have alternative options that can still get them funding. We also are utilizing a lot of bridge loans. So we have 4 different types of bridge loans. And so you're going to want to think of these as options for your buyer that currently owns a departing residence and either needs to qualify without that mortgage and or pull funds from the departing mortgage. So the most aggressive one we have actually takes over the mortgage payments for the departing home, sort of like a reverse mortgage, so that they don't have 2 mortgages while they're looking to sell their departing residence. So the way that this works is they purchase their new home first, they use the funds from the departing home within the bridge loan as a down payment, and the bridge loan actually takes over that mortgage, sort of like a reverse mortgage, so that they don't have to pay 2 mortgages at the same time. We have other ones that don't necessarily have to have those parts of it, so it just depends on what they qualify. But if you have a borrower who normally would have been contingent and you know that that's not going to fly, a bridge loan could be a good solution. And then lastly, we have our DML loan guarantee program. So what this is a conventional loan with as little as 5% down, where our underwriter, prior to your offer going in, will guarantee the value of the property so you can waive your appraisal contingency. So where we're seeing this win is when you're competing with multiple offers. Let's say there's 5, 10, 15 other offers. We're trying to give your borrower an edge. So the underwriter goes in, guarantees the value. Let's say we used one over here in Mays Chapel recently. The offer went in at like $450. Our guarantee was to $447 and the borrower was putting down 10%, so they could actually finance the $3,000 difference. Therefore, they waived the appraisal contingency. They didn't even let the property roll through the weekend, and they canceled the open house. So it really does give your buyers an edge, and we don't charge a higher rate or added fees. So keep this in mind if you think you're going to be competing. It really is like the cherry on top to help your borrower win. And that is all I have for you today.
And only one question is, they're loving what you're sharing. Can you send me the slides, so when I email everything, I can put all the slides in there with all your information?
Yes, definitely. And when I have more information about that new program, I'll post it on the Facebook page on Monday and also send it to you.
Great. Perfect.
So,
Thank you, Pam.
thank you guys.
Thank you so much.
Thank you.
All right, well, we appreciate you, Pam. We appreciate Emily for stopping by and giving us some great content. With that being said, for everybody who's online, we appreciate you. We'll be ending the Zoom now. And for all those who are here, let's go eat. Let's have some fun and grab some barbecue. See y'all soon. Thank you guys.